student have joined. To all of you, to our faculty and to all students for today's 14th day of online EDP. Our today's session under management skill is practical examples and case laws of insider trading. So students are going to get a very good practical knowledge on this topic because we have immense pleasure to welcome today's faculty. He is a very senior fellow member of our institute and having a rich experience of 20 years of experience in corporate sector, in listed companies as well as unlisted companies. So welcome you, sir, Mr. Deepak Manirkar. He has worked with companies such as very reputed companies such as Gabriel India Limited, Saint-Gobain, and Kirloskar Oil Engines Limited in the limited space, while his experience in the unlisted space includes companies such as Taco Composites Limited and Interwall Poonawalla Limited. During his tenure, he has handled varied subjects such as merger and amalgamations of listed and unlisted companies, NBFC compliances, conversion of companies to LLPs, implementation of legal compliance management tools, structured digital databases, preferential allotments, etc. Currently, he is working with Shri Renuka Sugars Limited, one of the largest sugar and ethanol manufacturers in India, as a company secretary and compliance officer. With this introduction, I welcome you, sir, and I really thank you for sparing your valuable time, for sharing your knowledge on today's topic.
Thank you, Priyanka. Thank you, Priyanka. Thank you, Shruti. So, all of you, all the students who are participating in this EDP, and it gives me immense pleasure to address all the students after a very long time. Let me share my screen with you. I have prepared a short presentation so that I can share with my students. Is the presentation visible? Yeah. Is the presentation visible, Priyanka?
Yes, sir. Yes, sir. It's visible.
Yeah. So before we go to any talking on any practical aspects of any subjects, I think we should be well versed with the technical knowledge of the subject so that we can understand the practical aspects as well. In this session, what I'm planning to do is to or guide you students on not only the technical part, but how the technical part is to be complied in practical life when you go into companies and handle the insider trading compliances in the companies. So this will be very useful for you when you join the company and handle the insider trading portfolio in the company. Some of the important definitions that we need to understand while we learn about, while we understand the insider trading regulations. First is the compliance officer. So who is the compliance officer? So basically, if you see the compliance officer, which is given in the PIT regulations, I'll refer the insider trading PIT regulations for brevity's sake. So for a definition of compliance officer, it says any senior officer who is designated as a compliance officer and reporting to the board of directors. And that senior officer must be financially literate. He must be capable of understanding the legal and regulatory requirements. And he must also be responsible for compliance of policies, procedures, maintenance of records, and monitoring of trades. Sorry. So if you see this part, it is nowhere mentioned that, this person should be a company secretary. So it can be any person in the company who has been designated as such for the purpose of insider trading compliances. This person can be a person different than your company secretary, and but the prerequisite is that this person should be able to understand all the legal requirements under the insider trading regulations. So ideally, if you see in any listed company, this person is basically the company secretary who is designated as the compliance officer for insider trading regulations. The role of the compliance officer in the company need not be highlighted. Uh, for any other compliance, likewise for insider trading also, the compliance officer plays a very crucial role in maintaining the records, in drafting the policies, drafting the procedures, and monitoring of trades, and basically uh, doing all the company has to do for enabling the insiders in the company and even for the company to comply with the insider trading regulations. Now, the second and the most important definition of insider trading regulations is a connected person. The person who is being associated with the company directly or indirectly in any capacity. Now, how is that association? Association being a merely an employee of the company. So the PI regulations have suggested that association can be, not should be, association can be by way of any of the following manners. So association can be by frequent communication with the company's officers. So if any person is frequently communicating with the company's officers, he can be treated as a connected person. Association can be by way of being in a contractual, fiduciary, or employment relation. Association can be by being a director, officer, or an employee of the company. Or the association can be by holding any position, including a professional or business relationship with the company, whether temporary or permanent. Now, there are a lot of people who are communicating with the company, a lot of people who are communicating with the company's officers. So are all these people connected persons? The answer is no. So to be a connected person, the association should be that this association allows such person directly or indirectly access to unpublished price sensitive information, or is reasonably expected to allow such access. So all association with the company need not be mean that a person is a connected person. The association should be in such manner that that person has access indirectly or indirectly to any unpublished price sensitive information. So for example, there might be an auditor of the company, there might be a secretarial auditor of the company, there might be a merchant banker, there might be the bankers of the company, or anybody else who has access to unpublished price sensitive information. I will refer this UPSI in short henceforth, so that we can save on time. So any person who has access to UPSI person, and not only the present, we have to go 6 months prior to a concerned act, see whether that person is associated with the company or not. So we have for 6 months from the date of his association with the company, that person can be treated as a connected person. If this is clear, can we move on to the next? Now, over and above the definition of connected person given the PIT regulations have said that some of the person will be deemed as connected persons. Now, who are these deemed connected persons? Deemed connected persons means those persons who are to be treated as connected persons even though they don't fulfill any of these criteria mentioned here. So are these connected persons? So the first definition given is immediate relatives of the connected persons. Now, when somebody falls into the definition of connected person as is given here, all his relatives the definition of immediate relatives, I will come to this later. So all the immediate relatives of the connected person will be treated as a connected person. So the holding company, associate company, or subsidiary company of this company will also be treated as a connected person. So if a company A Limited, the company which we are talking of, the holding company of A Limited, the subsidiary company of A Limited, and if there is any associate company, all these companies will come under the definition of a connected person. Third will be an intermediary specified in section 12 thereof. Now, all of you must be knowing the intermediary can be an RTA, a merchant banker, a broker, sub-broker, whosoever it is. People are deemed to be connected with the company. Investment company. So relative means immediate relatives. I'll come to the definition of immediate relatives after some time. It is not what is mentioned in 277 of the Companies Act, but it is a different definition given in the PIT regulations. So let me complete this. I'll come to the definition of immediate relatives. Investment company, trustee company, an asset management company, or an employee is treated as a deemed connected person. The stock exchange officials, clearing house, or corporations, they can also be treated as connected persons. Members of the board of trustees of a mutual fund or members of the board of directors of an AMC, they are also, or the employees of the AMC or mutual fund are treated as connected persons. Members of the board of directors of a public financial institutions or their employees, official or an employee of a self-regulatory organization or recognized or authorized by SEBI. Now, self-regulatory organization, one of you have raised the query, what is a self-regulatory organization? It is an organization which is recognized by SEBI to do certain acts and which has a charter of its own, which has a law of its own. And under that law, it is the law governs the functioning of that self-regulatory organizations. And these are the organizations which are termed as self-regulatory organizations. Bankers of the company and a concerned firm. Examples I need to check. I can check the examples and send you separately. Concerned company or association of persons where a director of a company or his immediate relative or a banker of the company has more than 10% of the holding or interest. So any firm, any partnership firm, any concern, proprietary concern, any trust, HUF company, or his immediate relative, and not only the director or his immediate relative, if banker of the company, if they are holding more than 10% of the holding interest, these persons will be treated as deemed connected persons. So is this clear up till now? Regarding the SRO, come back to you. Persons can all be other than mentioned. So was having any kind of contact with the company which allows directly or indirectly. Now, what does indirectly mean? So when you say indirectly, so you are a employee of a company, you are sharing some information to say any of your friends, and that any of your friends is sharing some information with some of their friends. So those on the line are treated to be indirectly connected with the company, or say auditor of a company. So auditor of the company has access to UPSI. So all the employees of the auditors, so handle this UPSI, will be indirectly connected with the company. So likewise, any connection which arises out of a direct connection will be treated as an indirect connection. So if some person is getting some person is getting to the company indirectly by way of some manner, so that person will be treated as an indirectly connected person. Like you can say merchant bankers employees, like employees, or employees of the bankers who yeah, there should be some nexus because the nexus will be with the company. Banks expect that the company should share some report quarterly basis or a monthly basis. So the bank's employees have access to the information which the public in large do not have. So these kind of connections are treated as indirect connections. So even though they are not directly getting the information directly from the company, since they are able to access the information from the company, they will be treated as indirectly connected, and they will come under the definition of connected persons. Now coming back to question of immediate relatives. Now immediate relatives are, the definition given is different than what is given in the in the Companies Act 277. So here immediate relatives means spouse of a person, parent, sibling, child of such person, or of the spouse. So all these people, they are to be treated as immediate connected persons of a deemed connected person. But to come under this definition of connected person, these immediate relatives must either dependent financially on such person or consult such person in taking decisions relating to trading in securities. So just because a person is my spouse or my child or my brother, sister, whatsoever, or my parent, just because of this, those people do not fall under the definition of a connected person. These persons must be financially dependent on me. Say if my parents are senior or my son is dependent on me for upbringing. So these people will be treated as connected persons. But if they are on their own, they are earning on their own, they are financially dependent, they don't consult me for any investment advice. So these people will not be treated as connected persons. However, please note that if I share any insider information with these people, which otherwise is not available generally to the public, and they act on the information that I have shared with them, that will be treated as a violation of the insider trading regulations, even though they are not treated as connected persons. Even though, say, if I share any UPSI with any of my banker, course of my in the course of my business activity or as a legal requirement, and does the banker or any of my relatives act on the basis of such information, so these people will be responsible for any action that SEBI might take for violation of IT regulations. So this will be clear when we go through the case laws of the subject at the end of this topics, which I will discuss. But the connection that the information has been shared between the company or any insider of the company with any banker. So when I'm submitting some reports to the bank or when I'm giving some information to auditors, we always have a trail, always have an email record of all the information that has been shared. So the auditors by themselves have an internal code of conduct relating to trading in the client securities. They are not supposed to trade in the client securities, but in the event they trade, they will be violating the PIT regulations and even their internal code of conduct, and they will be liable to action under both the situations. So they will be in trouble, in double trouble. So that is what we can say. So now, having seen what is a connected person and what is a deemed connected person, we will come to the main definition of insider. So insider is defined as by PIT as any person who is a connected person. Now, having seen who is a connected person and how a person can be connected, so any person who is a connected person will be deemed to be an insider. Any person doesn't fall under the definition of connected person as I explained before, but he has possession of or has access to unpublished price sensitive information or UPSI will also be treated as a connected person or an insider. So insider can be anybody who has access to UPSI. He need not be a connected person as defined in the PIT regulations, but just because he got some WhatsApp messages uh, regarding the results of the company before the results were published, that person can also be treated as an insider. Okay, so is this clear up till now? Okay, there's no response, so you can go ahead. Trading is also defined. So what constitutes trading under insider trading regulations? So trading means subscribing, buying, selling, dealing, agreeing to subscribe, buy, sell, deal in any securities. Now, one thing you must be clear to you that what is buying and selling. I hope you are also clear about what do you mean by selling. So subscribing means, say a company makes an offer of any kind of security, and any person subscribes to those securities. So this is the act of subscribing. Subscribing means applying for new securities of the company. Yes, WhatsApp chats have evidentiary value. We will see later when we discuss the case laws. So subscribing basically means when a company makes, say, a preferential allotment or a yes, subscribing means only we are talking of securities of a company which is subject matter of insider trading. So subscribing means the act of applying for the securities. Dealing, yes, somebody has pointed out that dealing includes pledge. So the word dealing has been made here to include pledging of shares. So why pledging of shares are included in the definition of trading? So it might happen sometimes that somebody has an insider information of the company in that sometimes in future the company is going to do some kind of a major act, and so it gives some loan to the company and pledges the shares of the company in exchange of those of the loan. And later on, when the prices of the shares increase, they exercise the pledge and they get the shares in their name. So they benefit from the insider information. So that is why dealing pledging is also included, kind of a is covered under the insider trading regulation. Just give me 2 minutes. Sorry. So not only subscribing, buying, selling, dealing, but even to agree to all these things will be considered as trading. In the anticipation, so if there is a agreement, a share subscription agreement which has happened, or a term sheet has been signed in the past to subscribe to the shares of the company, and based on that, its derivatives are also included in the trading. So if you are dealing in the trading derivatives of the company, that is also included. So even if a term sheet is signed to subscribe to the shares, then in that that also will be covered. That also will be covered as a trading in the company. So to agree to subscribe, agree to buy, sell, or deal in securities will also be covered in the definition of trading. Why this is important? When we'll see the case laws, I've shared some interesting case laws wherein you will see why even agreeing to subscribe is also covered, and how SEBI has used this to levy penalties on the defaulters. Can I continue? Okay. Is there any query which I have left unanswered? Okay. So this is another important definition. Securities of holding and associates will also be covered. Just a moment, I'll come to your queries. What is UP? So what we'll do, students, is basically keep all your queries ready. When I finish the session, we'll take the queries one by one. Is this okay with you? Yeah. Okay. Thank you. So I can just continue and keep your queries ready, so I can address all those queries at the end of the session. So what does unpublished price-sensitive information means? So UPSI has been defined in the PIT as any information which is relating to the company or its securities, directly or indirectly. So any information which matters, any information which relates to the company, the securities of the company, whether directly or indirectly, that information is not generally available, and generally available, that information is likely to materially affect the price of the security. So if you see here, it is if you see all information relating to the company is not UPSI. There are tons of information floating around in the company, but any information which is critical and which affects the price of the securities in a material way, that information will be treated as UPSI. So some of the students give some examples based on this definition of what can be possible UPSI. Yes, merger can be one. Takeover, yes. Resignation of auditors, yes. Buyback, financial results, changes in KMP, bonus issues. There can be some activities like no, death of MD cannot be a UPSI. I don't think so. Yeah, but any development which has happened in the company, but which is not yet informed to the public, and which is not generally available. Now, all these things, all these terms generally available, and all those things have been clearly dealt by SEBI in its judgments which they have given. So we'll come to those judgments and we'll understand these terms better. Yes, setting up of new unit, there can be a new product launch. There can be the company is getting a big order, which is a major order. Say a company having a turnover of 1,000 crores. Yeah, good students. I mean, you are well aware of all the events that can happen. So yeah, all these foreign collaborations, new outlet cannot. I think it is not so material to affect the price. Even changes in direct, if they are material, they will definitely come under the definition of UPSI. There can be some major orders which the company has got, but the quantum of the orders will depend on the materiality. Say a company having a turnover of 500 crores, if it gets an order of say 100 crores or 200 crores, yes, all these informations that you are sharing are very much UPSI. Thank you for your participation. So a company like having a turnover of 500 crores, it gets an order of say 200 crores. So for a company of the size of 500 crores, 200 crores is a big thing. So this will be an order which will materially, if this information is given to the public and shared with the stock exchange, this information will be definitely a UPSI. But say a company like L&T, which has a order book of say around 40,000, 50,000 crores at any given point of time, if it gets an order of 200, 300 crores, this will not be a material information. So, or say a company like Reliance, which gets an order of say 1,000 crores. For Reliance, 1,000 crores doesn't make any material change to its bottom line. So what is material will depend on the size of the company and how it will be affecting of the company in near term or the long term. Like recently, you must have read reports of Reliance getting so much of investments in the company. Those investments were really huge. I mean, those investments were like Reliance was able to wash off all its debts. So if you see the price of Reliance, it has grown from somewhere around 1,500, 1,600 rupees to now it is around 200, 2,300 rupees. So had this information, the Amazon deal and all those deals, the buying of Future Group, all this information, if Reliance had hidden from the public, would have the effect. The only person to benefit all this would be Mr. Mukesh Ambani, right? And all the people who are in the management of the company. A succession plan can be UPSI, provided it is material. So when Reliance announced all these deals, the effect of those deals on the price of Reliance in the stock market was evident. So all these deals were material. But Reliance would not go on declaring all the orders that it receives. Say any order of 200 crores, 300 crores it receives. It doesn't go on declaring all those things. So all these orders will be material. All this information will be material only if the information is material. I mean, if it affects the price of the company. Say when I say a company like a small company having around 1,000 crores turnover, so suddenly it bags a contract of say around 500 crores from somebody government office. So that will immediately have an effect on the price of the security. A person like Rakesh Jhunjhunwala or a person like Mr. Warren Buffett in the company, that will be a trigger point for the prices of the company. So that will immediately be affecting the price if it is disclosed. So this kind of information will be UPSI. So basically, for information to be UPSI, it should not be relating to the, it should be relating to the company, and it should not be generally available. And if it should be able to materially affect the price of the company. Yes, that is the essence of this information. So we will see in the case laws when we are going to discuss these case laws how time is of an essence. Okay, so I move to the next part. Unpublished means anything which is not available in public. What is available in public domain. If I note, there is a newspapers, and for a company is going to enter into so and so agreement. So, Varsha, we have discussed a lot of examples of UPSI. So, I'll come to the definition of generally available. How SEBI has interpreted the term generally available. In the PIT, if you see, it has mentioned that when you are disclosing any information on the stock exchange, it will be deemed to be generally available. But otherwise, say there is some information appearing in some small newspaper somewhere in any corner of the company. Yeah, public documents of the company is generally available information. So when I say a company, there is some information about the company appearing in any newspaper, any small newspaper which doesn't have any circulation. So that is not as this kind of death of director. No, it can not may or may not be an UPSI depending on the director's contribution to the company. So when coming back to generally available, say some news comes in Economic Times or say some news comes in Times of India. So information and this news is a credible news which the company has given. So this information can be treated as information that is generally available. Yes, any disclosure made to stock exchange is deemed generally available, but any news which has come in the newspapers, credible newspapers, and from credible and which is not in the nature of a speculative information will be treated as a generally available information. So if say a newspaper like Economic Times gives the information said that the company is likely to enter into this kind of an agreement or the company is likely to be taken over by some other company, which is speculative in nature. General availability always depends on the circulation. So if you are giving if any news appears in some obscure newspaper which doesn't have any material circulation, say only 1,000, 2,000, 10,000 copies are circulating in the entire country, that doesn't mean that the information is available generally. For the information to be generally available, it should be available to a majority of the public through a media which reaches the public, majority of the public. So if any media is not reaching to a particular major section of the public, this cannot be treated as generally available information. Okay. So say any small newspaper which doesn't have any circulation, treated as a generally available information. Another thing that SEBI has discussed in the past in its decisions is that the information should not, which is available in the newspapers, to be decided as generally available, should not be a speculative kind of an information. It should be a certain information. So any information which says that any news item in the newspaper which merely speculates and say it uses the words like the company is likely to enter into, or the company is in talks with somebody, or there is a possibility that the company will be merged with some other company, or there is a talk of some investment going on in the company. So this is merely a speculative information which is available in the press. Any insiders cannot take advantage of this news which have appeared in the newspaper and say that this is available generally, so I have traded in the securities of the company. So there should be some definitive information available, and it should be available in media which is widely circulated. In the majority are spread in this country, even in the world. So any information in any small time newspaper is not going to satisfy this condition of being a generally available information. So is this clear up to this? Can we move on to the next point? So all of you were spot on when you defined UPSI. So this is what UPSI has in the PIT. So UPSI has been defined to have mean financial results. So if you see this definition, it says shall include. So this is an inclusive definition. If you have learned about the interpretation of laws, you can say it is an inclusive definition. So it doesn't mean that only this information is a UPSI. So it has given examples of UPSI. There can be other kind of UPSI which are material for the prices of the company. Yes, further, for all events which are material can be added in addition to what has been given. So there is financial results, there are dividends, capital structure, restructuring, changes in KMP, and material events which are given in the listing agreement. So if you have studied the listing agreement in part A of schedule 3 of the listing agreement, yes, buybacks, all of these are material. Part 3 of in schedule A of part 3 of the listing agreement, now LODR, there are certain kind of informations, events which are given, which are to be treated as deemed material. No, this is not an exclusive, this is an inclusive definition. There can be any other transactions which can be covered in this definition of UPSI, which is not given here. So there are a host of events, if you see part A of schedule 3 of LODR, which are being treated as material events. So these are also to be treated as UPSI. So what SEBI is basically trying to say that these are the minimum events, minimum kind of events which are to be treated as UPSI. There can be events over and above these events which can be treated as UPSI if they are materially affecting the price of the company, or they are likely to materially affect the price of the company if it is available in public domain. Okay, like a company making a preferential allotment of shares. This can be a material. This can be a material UPSI. Can I move on? So having done with the definitions, we will come to the main part of PIT. What is the action that the PIT wants to regulate, and what is the kind of action that PIT? So the PIT puts certain restrictions on both insiders and connected persons and even recipients of the UPSI. So what are these kind of restrictions? So you will need to study this part in depth because this is the charging section, basic section of the insider trading regulation, and all the if you have read the case laws, you will see that all the case laws revolve around discharging section of the UPSI or the PIT regulations. So what does the PIT regulation try to prohibit? It says that no insider. Now you know what is an insider. So insider means any person who has access to UPSI. So no insider shall provide or allow access to. Now SEBI has tried to events under which an insider can share UPSI with any third party. So the insider cannot communicate any kind of UPSI coming suo moto kind of a thing. So even without somebody asking for any kind of information, if somebody provides the information to somebody else, this will be treated as a communication. It will be a one-way process. Provide means somebody asking for an information and you providing. Suppose some of you call me and tell me, okay, tell me what will be the results of September quarter. So you are asking for the information, and if I give you that information, it will be providing you that information. So there is a difference between communication and provision of information. If I tell you, I'll come to you this legal part. Yeah. So when I say in this, without you asking me, I tell you, okay, the results of my company in this September quarter will be excellent. You go and buy the shares right now. You have not asked me anything, but I have told you, okay, the results are going to be excellent. You buy the shares. So this is basically I'm communicating you the results. Yeah, this is communication. But me, okay, sir, so थोड़ा बता दीजिए नहीं ये रेणुका के results कैसे होंगे इस बार. And if I tell you, so basically I am providing you the results. Allowing access to. Having access to means if I give you access to some of the insider information which is lying in my computer, say via Zoom call or a chat or in any other manner. So you come to my office and tell me, okay, sir, I want to see your records, and I show you all the records. So this is allowing access. So even this unlisted subsidiaries of listed companies also applicable. So that is why when I said what is a connected persons, even unlisted subsidiaries are also treated as connected persons. So if there is a material subsidiary been consolidated into a listed company's results, and that material subsidiary does any transaction, or somebody does any major investment in the material subsidiary, or that material subsidiary receives any major orders, so even that will be treated as UPSI, because in the end the results of the material subsidiary are going to be more consolidated with the listed company, and that will have a bearing on the price of the securities of the listed company. Okay, so what is prohibited under the insider trading regulations is communication of UPSI, provide and allowing access to UPSI. So this is prohibited, but to who should not give. So the prohibition is to communicate, provide, or allowing access to UPSI to any person, including any other insider. Okay, so you as students are not insiders for me. Okay, you do not come under the definition of insiders to right now. So if I communicate any information to you, that will be treated as a violation of insider trading regulations. There can be a case that say I'm an insider of a company, say the CFO of a company. He has access to the financial results of the company before everyone else has. Okay, so I'll come to the examples of legal obligation when I discuss that topic. So as the CFO of a company, I have hands-on information about the company. Each and every number of the company, where the company is going, is known to me. So say somebody who comes under the definition of a connected person or a designated person as per the company's code of conduct, he asked me, भैया जरा बता दो ना इस क्वार्टर के रिजल्ट्स कैसे होने वाले हैं. Say the head of HR, he comes to me and asks me, sir, CFO sir, जरा बता दो ये कैसे है, मुझे थोड़ा shares खरीदी करना है. So if I provide this kind of an information to HR, who I have treated as an insider as per my code of conduct, so this kind of sharing of information even between insiders is prohibited. Okay. The prohibitions are of two kinds. One is the insider should not be giving any UPSI to person, and second, the insider is also not allowed to share any UPSI even with other insiders in the company or outside the company. Now there is an exception to this, and many of you have raised this question, whether what are the examples of where information can be shared legally. So information can be shared legally. Okay, information can be shared legally for legitimate purposes. Information can be shared legally for performance of duties. And information can be shared legally for discharge of legal obligations. Legitimate purposes, yes, legitimate purposes means you need to share information with the auditors. Okay, audit. You need to share information with your secretarial auditors. The company needs to share information. Suppose the company is going to make any issue of securities, then the company will need to share its future projections with bankers. So these are legitimate purposes. And if you see the insider trading regulations, SEBI has recently made amendment in the insider trading regulations, which says that the company should have a policy of defining what is a legitimate purpose. So the company is required to have a policy where it will say, okay, these 1, 2, 3, 4, 5, 6 transactions which I will treat as legitimate purpose, where I can share the UPSI. But when I share the UPSI for a legitimate purpose, does it mean that the recipient of the information is absolved of his responsibilities? We'll come to this later. So this is also an interesting thing. Exactly, UPSI with an insider, say the company has to define certain kind of persons in its organization which are to be treated as designated persons, and those designated persons are deemed insiders. So up to a certain level, say CEO plus down, like in my company, I have defined insiders as people in the grade of. So these can be from any area. This can be people from the technical side. This can be people from the HR side. This can be people from the legal side. So these people do not have any access to financial information, but they are insiders. So if they come to me and tell me, if the GM of a plant, if the plant head of any plant comes to me and tells me, sir, please tell me what are the expected results of the company for the quarter? Yeah, are there any plans of raising any funds which will be material? So if I give them such kind of information, see, I am an insider. They are also insiders as per my code of conduct. So if I give such kind of information to them, which help them in making a decision about buying the shares of the company or selling the shares of the company that they already have. So this will be an example of sharing information with an insider. But when I'm sharing information for any legitimate purpose, say some government organization wants the future projections of the company, or say I have to prepare a prospectus for a rights issue, or I have to prepare an offer document for a preferential allotment, or I have to give a future projections to my prospective lenders or investors. So in that case, I'm sharing this information by way of a legitimate purpose. I have some reason to share this information. So when the auditors ask for information for doing their audit, I cannot tell the auditors, भैया ये यूपीएस है, ये मैं आपको नहीं दे सकता, पहले मुझे स्टॉक एक्सचेंज कहेगा भैया नहीं, जब तक आप मुझे नहीं देते आप स्टॉक एक्सचेंज को बता भी नहीं सकते. So this is the kind of information which I am bound to give. This is a legitimate purpose. So this can come under the legitimate purpose and even performance of discharge of legal obligation. So tomorrow, if the auditor asks me to give some information for the purpose of the audit, or if I have to prepare a prospectus, or I have to prepare an open offer document and I have to give some information. So all these kind of sharing of information with the merchant bankers, or say to the brokers or to the RTA. So all this kind of information will be treated, sharing of information will be treated as if I am sharing this information for a legitimate purpose or performance of duty. Mere sharing of information for a legitimate purpose will not be treated as a violation. But if even for sharing of information for investigation or for auditors, as I said earlier, will be treated as I'll come to this question of auditor taking advantage of UPSI. I'll come to this. So this kind of sharing will be treated as an exception to the rule that I should not be communicating. But there is a duty cast on the recipient of information, which I'll come to that later, that how he should deal with that information. There is a duty cast on that. Merely because he is receiving the information for under a legitimate purpose doesn't absolve that recipient of his responsibilities not to act on that information. So I'll come to that part in the next part. So many of you are asking, what if the auditor takes advantage of the information which he is receiving, which the UPI that he is receiving in course of his audit. So what does the PIT has to say on this? The PIT receiving the information even for a legitimate purpose shall also be treated as an insider. So even an auditor or a trainee of an auditor who receives this information will be treated as an insider, and all the restrictions of Regulation 3, which we discussed before, this one, no insider shall communicate, provide, allow access to, or act upon. So all these restrictions on the insider will also be applicable to the recipient of information, even if such recipient is receiving the information for a legitimate purpose. And that person has to keep this information confidential. He cannot share this information with any of his friends, any of his family members, or to anyone else. Say a group of investors, that person is a part of a WhatsApp group of investors. He cannot share that information on such groups. भैया मैं इस कंपनी का ऑडिट कर रहा हूँ, ये कंपनी के रिजल्ट्स इस बार काफी अच्छे आने वाले हैं. Even if he shares such kind of information, even in such a very discreet manner, not allowed. And suppose somebody tomorrow finds this out, this person will land himself in big trouble with the SEBI. Is this clear on this up till now? Okay, what I'll do is I will answer all your queries, make a list of these queries. If possible, if there are major queries, you can always mail this to me. I'll share my email address. I think the institute has my email address, and share those queries with the institute. I'm welcome. I'll always respond to your queries. Thank you all for the excellent. Astrologers are not considered as insiders because that is a speculative kind of information. Thank you. I am extremely delighted with this feedback. I'll share my email address at the end of the session. Okay. Okay. Now, till now we saw that what are the restrictions on insiders. Now, what are the restrictions on others? It is not that just PIT regulations keep all the restrictions only for the insiders. There are certain kind of restrictions who are on people not treated as insiders. So what are these kind of restrictions? We'll move on to this. So what does the regulation say? The regulation say that no person. Now, please note the use of the word person. It is not mentioning no insider. It is not mentioning no connected person. It is mentioning person. So here, what it wants to cover is all kind of natural persons, all kind of artificial persons. So you must have learned the definition of the person when you have studied for your CS. So thank you for your comments. So person will include all kind of persons, whether that person is an individual, whether that person is a company, whether that person is a firm, because if the Income Tax Act, person includes everything. And person is not defined in the PIT regulations. So you have to go back to the income tax where the person is defined, or the General Act. No person shall, and here it is including all kinds of person, and it is not any kind of, it is not excluding any person at all. So even a common man on the street, if he is receiving any kind of information, will be covered under this. So what does the restriction say? No person shall procure information or cause the communication from any insider. So what does the PIT wants to prohibit here is kind of information from any. And what kind of information? Obviously, or yeah, there are lots of legal defenses will come when we come to the case laws. The second restriction is no person shall cause the communication from any insider. So like I was saying sometimes back, you as investors, say some of your investors, you must be regularly investing in the shares of the company, and I am the company secretary of the company. You cannot. What is prohibited is you are asking me to give any kind of UPSI, sharing any kind of UPSI with you. So if you tell me, okay, are there any plans of the company to raise funds from the public to reduce its debts, or what will be the results? Are you planning any dividends during this year, or are you making any new investments? Are you coming up with any new product? So if you are asking such kind of UPSI from me, remember I'm always referring to the term UPSI. I'm not referring to the term publicly available information. So if you're asking information from me, it is perfectly fine. But if you're asking any kind of UPSI from me, if you're forcing me to share any kind of UPSI, that is a violation of insider trading regulations. Again, asking for information, yes, it is a violation, but again, there are exceptions to these rules. As we, yes, there are restrictions on both the provider and the recipient of the information. So, as we saw earlier, that there are exceptions for sharing the information. There are also exceptions for asking the information. So, you can always ask information for legitimate purpose like audits or preparation of offer documents or takeover open offer documents. Or, yes, even any person who is not an insider is covered. You can ask information for performance of your duties. Say, like you must be knowing that companies generally have banking facilities with their bankers, and as a requirement, as per the agreement with the bankers, the company always has to provide the stock information on a monthly basis, or even has to provide projections on some periodical basis. So if you are providing this kind of information to the bankers, and if the banks are asking for such information, it is totally fine for a legitimate purpose and in performance of their duties. Okay. Now, if some regulator is asking to disclose some information in the offer document, that is also a perfect thing to do, because it is doing so in discharge of the legal obligations. If you see the ICDR regulations or the takeover regulations, when a company is making any kind of a public issue or a rights issue, or if the company is planning to do any kind of an open offer, if any person is doing an open offer, he has to share host of information. A lot of information has to be shared, and much of this information is also in the kind of UPSI. So if you are doing that, it is perfectly fine. But the only condition is the person who is accessing this information should not take advantage of this information and the securities of it. Okay, this is fine. Shall we move on? Which forms of and which is the crux of the AI regulations, and this is the section which is frequently referred to by SEBI. So what is this section? This is prohibition of the insider trading regulations, which says that no insider shall trade in listed securities or securities proposed to be listed when in possession of UPSI. Media can publish, but if it is a speculative information, it cannot be treated as a generally available information. And as I said earlier, you cannot rely on that publication in the media if it is in the kind of a speculation or something which may or may not happen in the future. So if any information which is appearing in the media of a possible transaction cannot be taken as any kind of speculative information. It is for media. At the most, what the company can do is the company can give a clarification on the stock exchanges. SEBI gets on the stock exchanges for giving any clarification on any news item which has appeared in any media. So your question regarding how does SEBI come to know of the insider trading regulation, SEBI violation of insider trading, SEBI comes to know when suo moto or when somebody provides any information to SEBI. If you are aware, the company has to make various on a timely basis. So based on those disclosures, when it analyzes those disclosures, SEBI can come to know of any possible violation of insider trading regulations. Like SEBI, when it compares the shareholding pattern of a particular quarter with the shareholding pattern of the next quarter, and if it finds that there is some change in the shareholding pattern, and in between these things, there is some kind of a unusual transaction which has happened in the company, which is a material transaction. So SEBI can always start investigating into the change in the shareholding pattern. Say the promoters held around 1 lakh shares in December 2019, but in March 2020, it appeared that the promoters are holding around 11 lakh shares. So it is promoters have acquired further 1 lakh shares in the company. Okay, the promoters might have given all kind of disclosures under the takeover regulations about the acquisition, but the company has not given any kind of information about any material event that is happening in the company. So during that event, during that quarter, it might have happened that the company is there is a possibility that somebody has proposed to be taking over the company or taking control over the company, or there is a possibility that or there might have happened. It might have happened that the company has raised some preferential allotment and redeemed some of its debts, or the company has planned some made an announcement of some major expansion, or company has entered in some collaboration agreement or a joint venture agreement, or some major subsidiary of a company has received some major orders, but which has not been disclosed. When SEBI compares the shareholding of the promoters in December and compares with the shareholding of the promoters in March, and change in the shareholding pattern, and meanwhile some major activities have happened in the company which were not earlier shared with the company, and when they were not shared with the company, they were UPSI. Gain relevant gain is not relevant. The fact that they have traded is relevant. So when and SEBI comes to know that in the shareholding of the promoters during the period when the information was not made public, it can always launch an investigation into the in the dealing. Do this dealing? Why did you do this dealing without informing the company, informing the public in large? So all these investigations can be launched. Okay, there are, if you see, many of the case laws which are arising out of this PIT are basically of this nature. So dealing of the promoters or any person when in possession of UPSI, 99% of the case laws deal arise out of this regulation. So this you can say is the backbone of the entire PIT regulations. No insider shall trade in listed securities or securities proposed to be listed when in possession of UPSI. Now, if you are a student of legal interpretation, it will be an interesting thing to note that each and every word in this sentence is of extreme importance. As you have seen, we'll go from the first word. We'll see a word insider. So you know now what insider means. So insider means any person who has access to UPSI. It might be a person who is in the employment of the company, who is not in the employment of the company, doesn't have has any relation with the company, who doesn't have any relation with the company. So all these people who have access to UPSI are treated as insiders. And what insiders should not do? They should not trade in listed securities supposed to list and they have UPSI with them. Okay, we'll go to the next word, which is no insider shall. Now, shall means it suggests a compulsion. It is a mandate. It doesn't give an option to the insider. It tells the insider that you should not be doing this. It is a compulsion. Trade in listed securities. You know, now we have dealt with the definition of trade. Trade means buy, sell, deal, or even trading plan. I'm coming to that. Even agreeing to buy or sell. So suppose you're entering into a share purchase agreement on the basis of some UPSI, which you know, even that is prohibited. So trading in listed securities. Now, I just wanted to have a general feedback from you. What does it mean only equity shares, or does it mean any other kind of securities also? Can you give some examples of securities which are not equity shares? So yes, very good, students. Debentures, preference shares, convertible debentures, redeemable debentures, bonds. So whatsoever securities are listed on the stock market and stock exchange. Stock exchange doesn't include only BSE, NSE, it includes all the recognized stock exchanges in India. It even includes the commodities exchanges. So all these kind of securities, yeah. So good. I mean, you're spot on. I mean, very good. Your knowledge is very good on this subject. So all these kind of securities are covered when it is said that insider shall not deal in the securities. So it doesn't. It's equity shares. It also covers all listed securities, which can be bonds, which can be debentures, which can be preference shares, anything. So basically, what it is saying till now, insider shall trade in listed securities or securities proposed to be listed. So it doesn't only cover which are securities which are listed. It also covers the burden of proof lies on the person making the allegation. This prohibition also covers securities which are proposed to be listed. Say a company which is unlisted till now, which has not listed its when it is going for listing, it has to ensure that not the company, the insider has to ensure that the securities in which he is dealing or trading should not be ones which are proposed to be listed. So even that will be covered, because when the securities are listed, the stock exchanges will discover the price, and it is possible that there might be a massive appreciation of the price when the securities are listed. And when is the restriction on trading? The restriction on trading is when the burden of proof lies on the person making the allegation. The restriction on trading is when the insider is in possession of UPSI. Of course, there are some other restrictions also on trading, but the main restriction is when a person is possessing UPSI, he or she or it cannot trade in the listed securities. And mind you, trading also includes to trade and not just actual trading, as has been understood. yeah, many of you have asked the questions, what are the different kind of defenses available? So if you see here, certain defenses which the law itself provides for trading in trading in security of UPSI. First is off-market interstate transfer between insiders who have the same UPSI and both of whom have made a conscious trade decision subject to reporting of such trades to the company. So there might be around 10 promoters in the company or 10 insiders. If the insider same information, they have access to the same information, and on the basis of the same information, they make an off-market transaction. This kind of trading is allowed provided this reported to the company, and the company in turn reports this to the stock exchanges. Second thing is, what is allowed is transaction in a block deal window between possession of UPSI. Now you have to basically understand common thing between point 1 and point 2 is that the trading is allowed between two persons who have, I'll come to the window, yeah, who have the same UPSI, okay, and not between persons who has UPSI and the person who doesn't have UPSI. So what is allowed is trading two persons who have the same kind of UPSI. No, this is not a trading window. So block deal means basically say block deal window which is window which is provided by a stock exchange for a company or an investor to enter into block deal. It might be a block deal, can be a purchase or sale between some other investors. Say a particular investor wants to sell say around 1 crore shares or wants to purchase say 1 crore shares, and there is another identified investor who wants to do a contra trade. Suppose I want to buy the shares, 1 crore shares in a company. You are one person who has 1 crore shares lying with you, but you don't want to channel of the stock exchange. So you approach the stock exchange to do to open a window for doing the block deal, and you do the trade only in that window. So there are no other persons who are involved in this block deal. It is only between me and you who are doing the trading. The price on the basis of in the same, yeah, it can be 9 no, it's not 9 and 9:15. It is during the market hours only. So it is a window which is specifically opened by the company to do a trade between two specific persons. Now you might be knowing that when you are doing trading in the shares of a company, say you are purchasing this website, you do not know who is purchasing your shares, or you do not know who is selling the shares to you. But in case of a block deal, you know that you are doing a deal with only a particular person. This is called a block deal. It is not a deal between two unidentified persons. It is a deal between two identified persons of an identified kind of securities, identified number of securities, and at an identified price. This is a block deal. So it is the block deal window. You have to apply to the stock exchange for a block deal. I didn't understand what are anchor investments. We can clarify it later. So we'll go on to the next defense which is available is transactions carried out due to any statutory obligation. So there might be certain statutory obligations, like say the promoters are in exit opportunity. Yes, I'm basically not aware of the criteria. I need to study that. So say the promoter's contribution is falling below the minimum as described in ICDR, which is 75% due to some issue, and the promoters are required as per ICDR to bring their holding to 75%. Say the promoter's holding is 80% or 90%, and the promoters are required to bring down their holding. So they are by law required to sell some of their shares to bring down their holding. So this is a statutory obligation which is under which transactions can be carried out. Or there might be some statutory obligation restructuring, where there is a restructuring, and in the merger or there is a merger or amalgamation, and because of the merger or amalgamation, the particular insiders get shares in the transfer or okay. So this is a statutory obligation. Transactions in exercise of persons of exercise of stock options is a new addition to this exception list which has been given. So if any of the employees who have stock options with them exercise those stock options, that doesn't come under the purview of trading in while possession of UPSI. Of course, the company has to disclose on a periodical basis how much stock options have been exercised. Trade as per trading plan. Now, what is a trading plan? We'll come to it in detail after some time, but trade as per trading plan is not covered under the prohibition. And in case of non-individual investors, if the person taking the trading decision is different from the person possessing certain information. Okay, so in case of non-individual investors, say like in case of the auditor, okay, audit firm I'm talking about, if the person who is taking the trading decision is a person different from my auditor to whom I am sharing the information, and there is no connect, obviously there should not be any connect between the possessing the information and the person who is taking a trading decision. Say in case of a merchant banker, okay, merchant banker to handle my preferential allotment or a rights issue, but the investment arm of the merchant banker buys some shares or deals in some shares of my company. Now this merchant banker, the person to whom I'm sharing my information for the preparing the offer document, is different from the person making the decision on investment. If both these two are not connected and they are taking independent, and the person making the investment is making an independent decision, then this will be a difference which will be available to the in case SEBI raises any investigations. But all these things must be proved during the investigation. Just because you are falling between these in all these criteria doesn't mean that you are exempt from the investigations. The investigations will happen, and you will have to prove that you're not guilty. Should I go on to the next one? As I said, while the charge can be raised by and proving that the person has done violation of the PIT regulations, has done trading when they are in possession of UPSI, is on the person making the charge. The onus of defending yourself, obviously, person on whom the charge has been made. Okay, so the connected persons, they have the onus, or the insiders, they have the onus of establishing that they were in possession of UPSI when the trading was done. This is not any rocket science. So if somebody makes an allegation on me that, okay, you have done a trading in the insider in violation of the PIT regulations, obviously it is my right and my prerogative and my duty to defend myself that I did not do any trading when I was of UPSI. This is nothing rocket science. It is just for the sake of clarification that has been inserted. After understanding what is UPSI, who is an insider, and what is prohibited under the insider trading regulations, we'll come to the administrative part of this insider trading regulations. Now there are some new concepts which have been inserted in the insider trading regulations recently by SEBI to strengthen the connected has the onus of proving himself, so he's always to be treated as an insider. If you see the definition of insider, it includes the connected persons by default. So we'll come to the SEBI monitor and how does the company monitor insider trading regulations or the violation of any insider trading regulations. The first part is structured digital database. Now, what is a structured digital database? This term has come into existence recently, which has been it's a recent amendment in 2019, which has been made by SEBI. What SEBI has mandated is that the company needs to maintain a structured digital database. What do you mean by you all know what is a digital database? It is a database which is maintained digitally, say in an Excel file. But SEBI doesn't want just an Excel file to be maintained. It wants that Excel file or that database should be maintained in a manner. There should be a particular structure to that. There should be a particular criteria when you are preparing that database. So what does the database should contain? That database should contain the names of persons who have shared the UPSI and to whom UPSI has been shared, and their PAN and other ALI. Now, it is the responsibility of the company to maintain a database of all the persons, not only persons or not only designated employees of the company, but all the persons to whom I have shared UPSI. Okay, is it understood till now? Now, if you see names that I have to enter, it is also the PAN that I have to enter. I have to enter in the database. The reason is very simple. PAN is the only universal, uniform legal entity, legal identifier, or can use, or the stock exchange can use to track any kind of trading which any person has done on the stock exchanges. All of you must be knowing that for doing any kind of trading, you need to have a trading account or you need to have an account with the broker. And you need to, when you open any demat account, you need to give your PAN number. So when you share your PAN number, you have already shared, the investors already share the PAN number when they open demat accounts or when they open the broking accounts. So with the help of this, SEBI or stock exchange can easily identify the actions done by a particular person during a past particular period. So using recording the PAN number is extremely important. Aadhaar number and all, no, the format of SDD is not given by the government, but the SDD has been, it has been prescribed that what it should contain. It should contain the full name, address, and the PAN number, mobile number. It also should contain the names of their immediate relatives, and it also should contain persons who have received UPSI should also be entered in the structured digital database, only the designated employees. So name, address, PAN number, names of, yes, SEBI keeps track through PAN numbers, the names of their immediate relatives, and even the educational qualifications and your past employment details are to be maintained. One more thing to note is that in addition to immediate relatives, even the details of persons who have, with whom the designated person or the insider has a material transaction during the last year, their names have also to be entered. Say you have given, some person has given a loan which is exceeding 10% of his total income to anybody. It can be even his son, it can be even to his brother, it can be even to his sister, it can be even to his friend. So if you have given any such kind of loan which exceeds 10% of your total income for the year, it has to be entered in the database. The name of that person to whom you have given your loan has to be entered in the database. Say if you, say somebody takes an education loan for children, and that education loan exceeds 10% of your total income during that year, yes, you have to enter the details of your children in that database. Third thing is, SDD should not be outsourced, it shall be maintained internally. There is a practice prevalent nowadays that the companies will outsource all their work to somebody, like say a practicing company secretary or a chartered accountant or anybody else. But what does the law say is that you cannot outsource the maintaining of this structured. LEI means legal entity identifier. And legal entity identifier means it can be anything. It can be a PAN number, it can be an Aadhaar number, it can be a Udyog Aadhaar number, it can be a GST registration number, it can be anything, any identifier of the government. So SDD is one thing which the company has to do itself. It cannot outsource that work. Like unlike audit, unlike filing of forms, which it outsources, unlike maintaining of statutory registers, which is outsourced by many companies, this is one thing which cannot be outsourced. It has to be done by the company internally, and it has to be done in the company's premises. It has to be done on the server of the company and not anywhere else. It has the control on the entire database has to be with the company. The login, the password, for accessing the database, for updating the database, for deleting the database has to be with the company and not with any other person. If it is found that this thing has been done out externally and somebody else is doing on behalf of the company, because IPs of the computers will be tracked, and if it is found that this database is maintained by a separate IP and not in the company IP, it will be treated as violation of this code of this regulation. The database should have adequate internal controls. Like I said, there should be a login ID and password which should be accessible only to the compliance of his team or to any person in the company who is maintaining this database. There should be a timestamp. Now you all know what is a timestamp. Timestamp means, say, when you're entering any particular information into the database, when you take a printout of that, it should show when this information has been entered, when this information has been deleted, when this information has been modified. Legal entity identifier. And this database should have audit trails. I am not sure why my voice is clearly. I request ICSI whether my voice is clear or not. Is it clear? Okay, thank you. So the SDD should have adequate internal controls. It should have all the information should be timestamped, and all the information should be capable of audit. So when you take a printout of that database, all the information, when the information is entered, when the information is modified, everything should come out when you take a printout of that database. This information has to be maintained for at least for 8 when after a particular entry has been made in the database in respect of a particular person. It's not that it is 8 years starts from the moment you make an entry for any person. For me, my name is entered in the database. I leave the company. My information in the database should be maintained for 8 years. It is not that all the information, all the person should be maintained for 8 years. It should be my information for a particular period. Should be maintained, like say when I leave the company, my information should remain with the company for at least 8 years. Or my information, even if I continue with the company, should be at least 8 years old. It can the information pertaining to period before 8 years can be deleted, but at least information, my transactions should be entered in the database for at least 8 years. Should be relevant for at least 8 years. Now we come to the disclosures part, which is again one more part of one more method. Yeah, which is I'll just quickly cover. We have time up to 1:30. Cover all the case laws also. So disclosures these are the disclosures prescribed in the insider trading regulations. So disclosures even include disclosures of trading by relatives, and even include disclosures by trading in disclosures of trading in derivatives of the company. And the disclosure has been, there are two types of disclosures prescribed. One is initial disclosure when you become a KMP, director or promoter. In that case, the disclosure has to be made within 7 days of such when you become the KMP, director or promoter. This disclosure has to be made to the company by the particular person, and the company in turn has to disclose this to the stock exchanges. Second disclosure type of disclosure is the disclosure by every promoter, designated person, and director who shall disclose to the company the details of the shares acquired or sold within 2 trading days of the transaction if the value in such trade is exceed 10 lakh rupees. So if a particular director, promoter, or a designated person is making any transaction and the value together exceeds 10 lakh. Suppose if I buy shares of 4 lakh and I sell shares of 6 lakh in a particular period. So when the total comes to 10 lakh, I have to give a disclosure to the company. It's not just that just purchases. If I only a particular kind should exceed 10 lakh. It is the aggregate of all transactions which has to be taken into account to calculate the traded value. It is not just purchase. exceed 10 lakh. It is not just sales that should exceed 10 lakh, but it is the aggregate of all the kind of transaction that you should exceed 10 lakh. If they exceed 10 lakh, I have to give a disclosure within 2 trading days to the company. And within 2 trading days of the company receiving this information, the information should be disclosed by the company to the stock exchange. Now here you have to note that the word used is trading days and not only days. So any Saturday, Sunday, yes, and company both have to keep a record of that disclosure. It is not just a day which is set. So if I do a trading on Friday, the deadline for me to give the disclosure to the company is Tuesday. So since Saturday and Sunday are not trading days, I can give my disclosure till Tuesday. It is not just voluntary disclosure. The company feels that some person has to give disclosures. It is not just pertaining to trading, but even if a person doesn't do any trading during the entire year, the company, by way of its code of conduct, can require all the designated persons, all the connected persons, to give disclosures at such frequency as the company may determine. Yes, even in case of transmission, you have to disclose. So the company, if the employees of the company do not hold any shares on an annual basis, or on a quarterly basis, half-yearly basis, they have to give the disclosure of their holding to the company. This disclosure is not required to be given by the company to the stock exchange. The company needs to have a code of practice for fair disclosure of UPSI and publish it on its website. So the company should have it is going to disclose its UPSI, in what manner it is going to disclose, and this code of practices for fair disclosure has to be published on the website. What I request the students is to go to the websites of some good listed companies. You will find a lot of policies which the companies have posted. There will be a policy of code of conduct for prohibition of restriction on insider trading. There will be this policy of disclosure of fair disclosure. So many companies have posted these policies on the website. Basically, it tells it wants to tell the world in what manner and in what no disclosure anytime during the day. It's not up to only 33:30. So basically wants to tell the world in what manner it is going to disclose the UPSI. The policies have to be made by the company, but the PIT regulations prescribe certain minimum criteria to be included in the policies. So it is not up to the company's whims and fancies that it can make the policies. If you see schedule B, I guess, regulation 8, which prescribes that there should be some minimum information which should be prescribed in the code of conduct and in the code of practices and procedures. It cannot say if as per the PIT regulations, disclosure requirement is that after trading in 50,000 shares, you should go for a pre-clearance. The company cannot prescribe the limit which is higher than 50,000. It can always have a limit which is lower than 50,000. It can always say that after 25,000 shares, trading in 25,000 shares, yeah, we are going to come back on that practical aspect. So all these are basically practical aspects only. We are covering what the company practically has to do when it comply with the insider trading regulations. There is also a disclosure which is prescribed. Now, system driven disclosure. December 2015, SEBI has automated information which it collects from the depositories. What is the role of the company in that? The role of the company is that the company has to disclose the names, PAN numbers, or any other legal identifiers of CEOs and employees 2 levels below the CEO and to the depositories. And what the depositories do is that they tag such information at the ISIN level. You know that a particular security has a particular ISIN. So equity shares of a particular company will have a particular ISIN. Preference shares of a particular ISIN. Debentures will have a particular ISIN. So they tag such account, this tag such PAN numbers with the ISINs. Now, so if there is any change in the PAN, in the holding of such PAN numbers in respect of the particular ISINs, the SEBI stock exchanges will immediately come to know of such changes, because the depositories have to share this identified data to the stock exchange. So the companies cannot, or the insiders cannot get away scot-free that they have not shared, so they can do anything. Now the SEBI is continuously having a look at your tradings. Trading plan, one way out of all these restrictions of trading is by way of a trading plan. There are a lot of exemptions which have been given when you formulate a trading plan and submit it to the company, and this trading plan is made public. So a lot of restrictions which have been prescribed in the PIT, like no trading in the closure of trading window or no contra trades, are not applicable when you disclose a trading plan to the stock exchange. However, certain conditions to be prescribed fulfilled when you do a trading plan. I will not go into all these things in detail due to shortage of time. One more thing now, every company, when you go, all of you may go to a listed company to as a career. You might choose a listed company as a career. So when you go to a listed company, you will find that these listed companies will have a code of conduct which the company has to prepare under Regulation 8. The Schedule B of this PIT regulations prescribe the minimum conditions that needs to be included in the code of conduct. Like I said, that the code of conduct will prescribe a minimum number or minimum value over and above which the company will the concerned designated person or the insider will have to go for a pre-clearance or disclosure. The company has no choice to relax these conditions, but it has always has the choice to further strengthen these conditions. Like if it is 50,000 shares, the company can always say that after 25,000 shares, you will need to report. There are other prescribed procedures like Chinese wall procedures, processes to cross the Chinese wall, which have to be prescribed. Now, what is a Chinese wall, right? The Chinese wall is basically a wall inside which all the restricted information is stored. You can imagine that in the company, separate department, separate accounts department, which where accounts team works. No other person is allowed to enter that. No other person is allowed to access the computers of those people. And you might see in some companies that no access is allowed. You might see that access to that accounts department will be only on a need to know basis. They will always ask question, why do you want to enter this department? Okay, so like there might be restrictions such as biometric access or card access only to a particular person. The cards with biometrics will be restricted for a particular kind of people. So all these things will be there. So there will be a process to cross the wall. Now, what do you mean by process to cross the wall? Process to cross the wall means how can a person who's not part of that enclosure enter that enclosure? What will be the permissions that will be required? For what reasons he can enter? So all these processes have to be prescribed in the code of conduct. When you go to companies, listed companies, you will find this kind of processes. You will not be able to access the accounts team very easily. Let's to say all the files in that Chinese wall area should have adequate security, or the login ID password should be there even for accessing the computers. Trading window. Yeah, this is a practical aspect that you will come across when you go in companies. There is a concept called a trading window. Now, this trading window means this window is either open or this window is closed. When this window is opened, the insiders or the can trade the securities of the company. When the window is closed, the insiders or the designated persons cannot deal in the securities of the company, even by way of a pre-clearance. Now, when is this trading window closed? Who determines the closure of trading window? Is there any mandated period which is given in the PIT? Yes. Trading window is it is the compliance officer who decides when to close a trading window. So when a compliance officer has reason to believe that a particular person or a class of persons who are designated persons have access to UPSI, he will immediately inform those person or class of persons to close the trading windows. That okay, for you the trading window is closed till such time you make the information. No off-market transactions also allowed in. So he will inform those particular persons or class of persons who have UPSI that you cannot deal in the shares of the company or the securities of the company unless this UPSI is made public. Apart from this, trading window is really required to be closed by the company from the end of every quarter till 48 hours the declaration of results of that quarter. So there is no option, but there is a mandate that from the end of quarters. For example, for September quarter, the closure of trading windows for all listed companies will start from 30th September and will go on till 48 hours after the declaration of results. Now, please, as students, please keep watch on all the announcements made by listed companies from now on. You will find that there are announcements made by companies at the meeting, and there are announcements also made of the closure of trading windows. If you see even for last 1 year, you will see that before the end of every quarter, there are companies which are declaring closure of trading windows. There is one more thing specified that the time announced by the audit committee and approval by the board should be as narrow as possible in order to avoid leakage of UPSI, or the results being leaked in the market. Compliance officer also determines when trading window be open, and trading by the designated persons is not allowed even when the pre-clearance of trades is given by the compliance officer during the trading window is closed. Understood till now? Should I go to the next, or should I directly go to the case laws? Yeah, it is case laws now. Nothing is there. So please understand that this trading window is one such tool which is available to the companies, which is used to control the trade in the share securities of the company by the designated persons or the insiders. Okay, we'll go to the most interesting part, which is the case laws. Has anybody read any case laws on insider trading? Are you aware of any? Yeah, good. So it will be easy for me to explain. Even if you have not read the case laws, no issues. I have selected some five very interesting and important case laws, which can be treated as landmark case laws or recent case laws under the PIT regulations. And if you see, when trading window is open, no trading can be done when you are in possession of UPSI. So if you see, there is a procedure for pre-clearance where you have to apply for trading in the securities of the company, and the compliance officer needs to give a clearance for trading. So even if you have a pre-clearance of trade, even if you have a trading window open, you cannot trade in the securities when you have reason to believe that you are in possession of UPSI. When you know that you are in possession of certain information which is UPSI, which is not generally available with the public, which is critical for the which may have a critical bearing on the prices of the securities, you are not allowed to the securities of the company. This is the basic premise which we discussed earlier. The basic provision of PIT which say that you cannot deal in securities of a company when in possession of UPSI. Yeah, we'll go to case 1. So as far as possible, I have tried to keep the names silent. Yes, I'm dealing with the Rajaratnam case also. So I have tried to keep the names silent to avoid any kind of views being taken on any particular person. So here we are dealing with a case where Mr. A, who was the chairman and managing director of a listed company A Limited, visited the office. Now, when I'm discussing these case laws, please have particular attention to the dates. These dates are very important. Okay, so Mr. A, who is the chairman of a listed company A Limited, visited the office of B Limited for discussing whether B of A Limited. He visited the office during 5th September to 8th September and held talks with the officials of B Limited for inquiring whether B Limited can take control of B Limited. B Limited informed A Limited that the deal can be finalized, but Mr. A should ensure that B Limited is able to acquire at least 51% shares in A Limited. So the condition which was put by B Limited to acquire control over A Limited was that Mr. A should ensure that B Limited is able to acquire at least 51% shares. Because it had come to the notice of B Limited that A Limited, who is also the promoter of the company, is not in possession of 51% shares. So to acquire control, B Limited told Mr. A that look, we can acquire control of your company, but we also need decision-making power. You all know that for getting any resolution approved in the general meeting, at least an ordinary resolution is required. For that, at least more than 50% of the votes cast should be in favor of that resolution. Yes, majority stake. Why majority stake? Because majority stakes enables you to take control over the affairs of the company. So if you have a majority stake, you can do a lot of things which you cannot do with majority stake. So B Limited told Mr. A that look, we can acquire control, but we should have at least 51%. And Mr. A 51%. So what he did was on 25th September, when he to know that okay, we are now B Limited is somewhere close to acquiring control or is agreeable to acquire control, he told his relative that you purchase around 2 lakh shares of A Limited. Why did he tell so? Because by this way he could ensure that and what he did was he helped his relative, say we can name him Mr. B. He gave him some money out of his own funds and told him that look, you acquire 2 lakh shares, we have to transfer the shares to B Limited so that B Limited can have at least 51%. Here there was no element of profit making. If you observe this was done by Mr. A just to ensure B Limited gets control over at least 51% stake in A Limited after the agreement is entered into. So after the relative shares, the deal was finalized and the disclosures were made to the stock exchange. Now what SEBI did was, SEBI took a view was that since there was no information about the proposed change of control exchange, the period after 5th September should be treated, whatever information arose after 5th September, that deal should be treated as UPSI. You may note that, this was that the information about the deal was given only on 20th September by the company, the stock exchange. Between 5th September and 20th September, no information was given. So SEBI took a view that between 5th September and 20th September, whatever information has arisen out of this deal is to be treated as UPSI because you have not informed anything to the stock exchange. And since Mr. A has provided funds to his relative to acquire the shares of the company, that trading should be treated as violation of Regulation 3. Regulation 3 means all know that Regulation 3 prescribes that no trading should be done on the basis of UPSI, which you have. So what SEBI came to a conclusion that Mr. A was in possession of UPSI that B Limited is going to acquire control over A Limited. And in anticipation of that, you knew that A Limited's skyrocket after this deal is made to the public. And knowing this information, you also traded in the shares of the company. So a penalty of 3.4 crores on Mr. A for violation of Regulation 3. This amount was directed by the SEBI that you deposit this amount in the investor protection fund of the stock exchanges. Now please note that this is IPEF and not IEPF as mentioned by MC as it is given in the Companies Act. Is a different thing and IEPF is a different thing. IPEF is the fund which is constituted by the stock exchanges. Okay, so on the basis of this fact, SEBI levied a penalty of 3.4 crores on Mr. A for violation of Regulation 3. Mr. A went in appeal to the Securities Appellate Tribunal. So all the actions under the securities laws can be taken by SEBI only, and all appeals against the orders of SEBI can be with Securities Appellate Tribunal. So Mr. A appealed to the Securities Appellate Tribunal against the order of SEBI. The Securities Appellate Tribunal had certain legal interpretations or decisions to make on certain legal issues. First issue before it was whether the information which had arisen before 20th September was UPSI. So the Securities Tribunal had to decide whether there was actually a UPSI in existence before 20th September. So yes, there was a UPSI. So the SAT came to a conclusion, yes, because this information about possible change of control of A Limited was not informed to the stock exchanges, was not discussed anywhere. UPSI was in existence. And even the fact that media carried the news of a possible deal was not sufficient to treat it not being a UPSI. So as we discussed earlier, any speculative information about any particular deal or a transaction in the media give a defense to you to be not to be treated as a UPSI. If is of a confirmed nature which is issued by the company, only it can be said that the information is publicly available. Otherwise, a mere speculation by the media about a probable transaction should not be treated as information being publicly available. So SEBI came to the conclusions. One, the information was before 20th September about a possible change of control was UPSI, yes. But it also said that just because the media carried the news of the possible deal doesn't mean that this information is a publicly available information, because it brought to the notice parties that the information which was circulated in the media was of a speculative nature, of a possible deal. There is a probability of a deal. So it is not a confirmed information. Whether Mencia was an essential ingredient to the penalty under the PIT, Mencia, you all know, is intention of making a profit. So SEBI was of the view that no SEBI, guilty mind or intention of defrauding or whatever. SEBI was of the view that Mencia is not an essential ingredient. Just because you have violated Regulation 3 gives you enough reason for a fine to be imposed for the violation of the on the defaulters. But the ACT held a contrary view. It held that is an essential ingredient because SEBI has not gone to the root of the law. The main, if you, as we call it in the legal terms, the spirit of law. It has overlooked the spirit of law. The spirit of law is basically to protect investors. Here, what has happened was Mr. A had asked his relatives to purchase 2 lakh shares of A Limited just to ensure that the deal between B Limited and A Limited doesn't fall off. There might be contrary decisions by SEBI. Here, it says that Mencia was an essential ingredient. This is the decision of the SET and not a decision of SEBI. Okay, so here, SET brought it to the notice of SEBI that the purchase of shares by Mr. A's relative was just to ensure that the deal between B Limited and A Limited doesn't fall off, and it is to ensure that Mr. A makes any profit out of the deal. And so there was no guilty mind. In the intent was not any violation of law, but the intent was that the deal should go through. So there was a legitimate purpose for Mr. A to purchase the shares because A Limited was in a precarious condition. It was not in a good shape, and it was important that B Limited takes control of A Limited so that the business of A Limited continues. So that was one decision which was an important decision. SEBI was turned around, and the fourth important decision was whether SEBI was authorized to direct deposit of funds in IPF. So at the law that stood at that point of time, there was power given to SEBI under the PIT to direct levy of penalty and deposit of funds into IPF. The power given to SEBI was just to make a fact find. So after this decision, so when SET gave a decision that then SEBI has no powers, so this law was basically amended to give SEBI all these powers. So the crux of the information here is you'll understand is that when does the UPSI start? The period of UPSI start. As we discussed in the beginning, that the dates are very important, and even the agreement to purchase or sell is also relevant. So there was a tentative agreement by B Limited to purchase the shares of to take control of A Limited on 5th September when Mr. A visited the office of B Limited for discussing the proposed turnover. Is this case law clear to you? What do you understand from this case law? I want some feedback on this. Yes, all cases are decided on the basis of actual facts, and we should see the reason why a particular insider has made any transaction. Not just it's not that just because he has purchased shares means that he has violated the PIT regulations. The reason for purchasing is important, and whether he has a guilty mind, whether he has an intention of making profits to the loss of all was also important. Here, ACT came to a conclusion that forget the fact that he was defrauding the shareholders of the company. Mr. A was acting for the benefit of the shareholders of the company, because had this deal not happened, A Limited would have gone into losses or would have been liquidated or become insolvent, and the shares would have actually plummeted. Since the deal was made, the shares rebounded, the company's shareholders benefited. So this deal was in fact for the benefit of the shareholders and not for defrauding the shareholders. So the crux of that intricacies, lot of intricacies are there. The time will not permit us to discuss the intricacies. So the crux of the decision, an essential ingredient for levy penalty under the PIT. Just because any news is published in any newspaper doesn't mean that it is publicly available information. Even if you see, the dates are also important. SEBI has said that 5th September is the date when the UPSI came into existence. We'll go on to the next. Thank you. This case pertains to proposal of taking control over a particular company by giving a loan. So there was one company, I Limited, which had the management of I Limited had discussed a proposal in its management committee meeting of giving a loan to P Limited against its securities. The meeting of I Limited to discuss this happened on 25th January. The decision was taken. The loan was given, and the loan was given against the pledge of securities of P Limited to I Limited. On 15 March, the pledge was, I Limited exercised the pledge option, and the shares of P Limited were to I Limited, and this transaction was disclosed to the exchanges on the same day, in March. During the period January, when the decision of P Limited was taken, mind you, this decision of lending was taken with the very intention of taking control of P Limited. The loan was given basically only P Limited on a future date, and it was not for any other purpose. It was always the intention that the pledge will be invoked and the shares of P Limited will be transferred to I Limited, and I Limited will take the control of P Limited. During this period after 25th January, when this decision of lending was taken, Mr. P was the member of the board of I Limited, traded the shares of I Limited and made a profit of 70 lakh. To know of it, he started investigations, and it came to a conclusion that there was a violation of PIT regulations, and it held that P Limited, being a member of the board of I Limited, was aware of the transaction of the sale of P Limited to I Limited. It also held that the UPSI arose after 25th January. So any trading which was made after 25th January to 15 March was to be held as trading while in possession of UPSI, and therefore Mr. P was held as being guilty of violation of the PIT regulations, and he was levied a penalty of around 87 lakh. So this is a very simple case that the UPSI was available with Mr. P Limited being a member of the management of I Limited. This information was not disclosed to the stock exchange. As a result of this transaction, there was a change in management, and after the change in management, after the control of P Limited being taken over by I Limited, the shares of I Limited skyrocketed, or it increased substantially. And Mr. P, who was always aware of this impending sale, made a profit on the shares of I Limited on the basis of the information he had with him, which was not shared to the stock exchange. We'll go to the next case. This is a very recent case, and you must all have heard about this. This is the WhatsApp case. Here I have disclosed all the names because basically this information, everything is there in the media. So SEBI got to know that there was certain financial information of revenues and operating profits being circulated in certain WhatsApp groups of certain companies, and when these companies disclosed their financial results, the information which was circulated on the WhatsApp groups matched very closely with the figures which were disclosed by the companies. So SEBI made a detailed investigation. It seized a lot of. It will be interesting to know that it seized a lot of phones. It tracked WhatsApp chats of a lot of WhatsApp chats which carried on between different groups, and it came to a conclusion that one Miss Shruti Vora, who was working with a stockbroking firm, and Mr. Parthiv Dalal, they were circulating insider information. They were taking information from the companies about the financial revenues and operating profits and other information to their clients who were part of a WhatsApp group, and then those clients were trading in the shares of those companies and making profits on the basis of the unpublished information. And not only making profits, some of them were selling the shares in advance and avoiding losses also. So SEBI found that this is in violation of Regulation 3 of PIT, because the people who were found guilty were circulating figures which were not in public domain. Ms. Vora, who was found guilty of circulating messages of 3 companies, she was levied a penalty of 15 lakh per company, and Mr. Dalal was found guilty of circulating information of 1 company. And it didn't stop here. SEBI also directed the concerned companies to look into the matter, because to find out who is giving out this information from the company side, because Shruti Vora was not working. Shruti Vora was working with a stockbroking firm, and SEBI asked the companies to do their own investigations. Yeah, it was not related to the company. It was, it might be that the stockbroking firm must be dealing with the company day in, day out, or the people in the stockbroking firm might be knowing the people in the company. So the SEBI asked the companies to find out who is leaking this information from the company. It is possible that the stockbroking firm people might be getting the information on their own. There must be somebody in the company who is leaking this information. So the SEBI asked the companies to investigate, but the company said they are not able to pinpoint any particular person who is leaking the information from their end. So the investigation into the companies came to a halt there. See, the violation in this case is trading on the basis of UPSIs. These broking firms, they were circulating unpublished financial information to their clients, who were acting on the basis of this unpublished financial information and trading in the securities of those companies. And later on, it was found that this information was very much close to the figures which were disclosed by the company. So the people traded and made profits, and not only made profits, also avoided losses in certain cases. Rajaratnam case, or Mr. Rajat Gupta case. You must have all read about this case. So this is not a case under the Indian insider trading laws, but it's a case under the US insider trading regulations. But this is even relevant in the Indian context, because it is based on the same premise of trading on the basis of UPSI or sharing of UPSI. Who was the CMD of McKinsey and also board member of Goldman Sachs. You must be knowing almost knowing what has happened to Goldman Sachs in 2008. Anybody knows what happened to Goldman Sachs in 2008? Okay, Goldman Sachs. Yeah, some of you might be knowing Goldman Sachs is a big merchant banking firm, even which is also investment banking firm, you can say. And it incurred huge losses due to some trades which it had done. It was virtually on the verge of collapse. If you track the stock market of 2008, if you go back and track the stock market of 2008, you will see that during 2008, the Indian stock market collapsed heavily. I mean, it reduced by at least 50% from its levels. This is because of the collapse of Goldman Sachs. So Mr. Rajat Gupta, who was the CMD, was also a board member of Goldman Sachs. Before the meeting of Goldman Sachs, Mr. Gupta learned that Berkshire Hathaway, you must all be knowing Berkshire Hathaway. Anybody know Berkshire Hathaway? Yeah, this depression period in the stock market was because of the Goldman. Yeah, the Berkshire Hathaway is the investment firm of Mr. Warren Buffett. So Mr. Gupta came to know that Berkshire Hathaway was going to pump $5 billion in Goldman Sachs for 2008. And the board meeting, he came to know about this on 21st September. Warren Buffett is the owner of Berkshire Hathaway. All the funds come from Mr. Warren Buffett. You can say that. So he came to know this on 21st September that Berkshire Hathaway was going to pump $5 billion in Goldman Sachs. He immediately called Mr. Rajaratnam. I'll refer him as Mr. Raj. Actually, Mr. Raj is a person of a Sri Lankan origin. He's a Sri Lankan national. He called Mr. Raj Gallian and told him about this possible deal on the 22nd September. He got about 80,000 shares of Goldman Sachs on 22nd September. Again, on 23rd September, before the announcement was made by Goldman Sachs, or before the announcement was made by Berkshire Hathaway, Mr. Gupta again Raj on 23rd September that there is going to be an announcement to be made about this investment. And immediately after this call, Gallian purchased another 40,000 shares of Goldman Sachs. This went to Berkshire Hathaway invested $5 billion. And because of after the, I think I've answered a lot of questions. If there are still any questions, you can always send me an email, so I'll answer individually all those questions. Priyanka, can you share my email address, so if they have any queries, they can ask them on email. So, yeah. So I'll not take a lot of time. This is only the second last case law that I'm sharing. Getting profit of $14 million out of this trade, and it also avoided losses of $3 million with the help of this UPSI Mr. Gupta had shared. It also came to the notice of SEC, that is the Securities and Exchange Commission, that they had made a profit of $500,000 on the shares of Procter and Gamble with the help of UPSI, which was shared again by Mr. Gupta. So there was a investigation into the call records of Mr. Gupta, Mr. Rajaratnam, and at the end of all, Mr. Gupta was fined $13.9 million plus a criminal fine of $5 million and sentenced to 2 years of imprisonment. Mr. Gupta was also barred from acting as a director or officer of any public company. What happened? Again, yeah, he didn't go scot-free. He was fined the heaviest, $93 million plus disgorgement of profits and 11 years of imprisonment. So you can see what is the penalty you can incur if you are violating the PIT regulations. The next case that go is on purpose I marked this case as red. This is because it pertains to our profession. There was a company e-Limited, which is a subsidiary. Yeah, if I tell you the penalty which can be levied, you will be surprised. So e-Limited is a subsidiary of F Limited, which was a listed company. This e-Limited acquired a stake in A Private Limited on April by making a share purchase agreement. The disclosure about this acquisition was made on 15th April, but the term sheet of the acquisition was signed on 25th January. That means the agreement to trade or agreement to subscribe happened on 25th January. Now, if you remember what I told you earlier in the session was, even agreement to trade or agreement to subscribe is deemed as trading. Okay, so agreement to trade happened on 25th January. As the UPSI came into existence on 25th January, that e-Limited is going to acquire a stake in A Private Limited. F Limited, in the meantime, failed to close the trading window on 25th January when UPSI came into existence. Now, if you see, we learned earlier, when is the compliance officer required to close the trading window? The compliance officer is required to close the trading window when he comes to know that a particular. Yeah, I'll show the case law after. I can even share this slideshow with the institute. You can take it from. So, as we learned earlier, the compliance officer has to close the trading window for people who he believes are in the knowledge of UPSI. When he comes to know that the UPSI has come into existence. So, the CS of F Limited was aware that the UPSI that E Limited is going to invest in A Private Limited had come into existence on 25th January, but he failed to close the trading window on 25th January. SEBI investigated into the matter. SEBI also came to know that this company F Limited, the trading window intimation was not being given to the stock exchange for a very long time. As you know that the company has to close the trading window and has to give an intimation to the stock exchange about the date of trading closure trading window. So the investigations revealed that Limited was not even giving the intimations of the trading window closure, and it started giving such intimations only from 2019 January. So he is guilty of non-compliance and for not closing the trading window. The shares of the company, he has not shared the information UPSI of the company, he has not acquired the information of the company from anybody else, he has not made any profit out of any of the dealings, but the only thing the CS failed to do was he did not close the trading window in time. So for this he was penalized 5 lakhs. So when you own companies as company secretaries and compliance officers for you are available on Google if you search. This is basically the case of Edelweiss. Not share the names of the case laws. All these case laws are available if you search on the case laws for insider trading. So here in this case, even though the company secretary has not dealt with any shares of the company, just for a small violation of not closing the trading window, he insider trading regulations, the penalty for violation of insider trading window till 5th April, when the disclosure about acquisition was made on 5th April. He should have closed the trading window on 25th Jan, and he should have closed it on 5th April. So trading close, even closure of violation for closure of trading window is an offense. If you see the penalties prescribed for violation of the insider trading regulations, they are prescribed in section 15G, yes. But section 15G prescribes penalties only for the violation of the requirement of sharing of UPSI and trade of UPSI, while the penalties are anywhere between 10 lakh to 25 crores. But in this violation, there is no prescribed penalty. So you have to look at another section in another subsection of section 15, where it is said that where no penalty is prescribed, closure goes from 25th January to 5th April. Where no penalty is prescribed for any particular violation, general and range from 1 lakh to 1 crore. And the company secretary of this company was penalized for under this section for 5 lakh rupees. So it is important for you students, when you graduate from being students to being company secretaries, to be very vigilant at time management about the trading window closure to allow or not allow particular trade. Even you have to start saying no to even to your chairman when he applies for pre-clearance. One interesting fact about the trading window is that if you have noticed that since 22nd March we are all in lockdown, and accordingly SEBI has extended the dates for the disclosure of the results, but it has not relaxed the trading window closure. So for many companies, the trading window 31st of March has not ended even now, because 15th September was the last date for disclosure of the June quarter results. So many, and 30th June was the last date for disclosure of the March results. 15th July, sorry. So for many companies, the trading window which started from 31st of March has not closed even up till now. So those companies which had declared the results after 30th June or have not yet declared their June quarter results till 15th September, it's almost a 6-month trading window closure. On my part, a very interesting discussion with you, I can say, because it was a very good participated very in this session. If you have any queries, I'll stop the sharing so that I can. What I can say, I can put my email address in the chat box. You can all note my email address. It is deepakmanirika@gmail.com. If you have any queries, you can post those queries on this email address. Whenever I find time, I can reply to you. Thank you everyone for your active participation. Thank you. Over to you, Priyanka.
Thank you so much, sir. Thank you for sparing your valuable time for today's session. I must say that it's really an interactive session because as the way you have taken the question during the session of all the student, it was quite interactive, and student has responded very well to all your questions, and they have attended the session very actively. So thank you to all students as well, and I'm sure that the student have learned very well the practical knowledge on today's topic because you have taken really wonderful case studies on the topic. So with these words, I thank you to all of you for attending the session with all your cooperation with your for all your cooperation. Thank you so much, sir. Once again, take care and be safe. Take care of yourself, sir. Thank you, sir.